Lauren Mulrain back with you for the course, Part 5, Copyright Law Part 5. We're talking today about fair use. And I know most of you have heard the phrase fair use because it's the most popular defense to copyright infringement. So today's video will just talk about the basics of fair use. We're not going to be here long. But we'll tell you what it takes to have a fair use defense. So first of all, of course, there must be a copyright infringement suit. Someone believes that you have infringed on their copyright and you have to defend it. And one of the ways to defend is by saying, I may have made use of the work, but my use was what we call a fair use because of the way that I used or how much I used it or the circumstances in which it was used. So one of the things that the courts look at is whether or not there's been a transformative use. In other words, is the new use transforming the work in such a way that it clearly is different from the original? New expression, new meaning, new message. Are you putting that into the new work? If so, then that creates a greater likelihood that it would be considered fair use. But that doesn't mean that it automatically will be fair use. There are 4 factors in every fair use case that are evaluated by the courts. The first factor is the purpose and the character of the use. The purpose and the character of the use. The second one is the nature of the copyrighted work. The third one is the amount and substantiality of the use, how much of the work or the substantialness of the use. And the fourth factor is the effect on the commercial marketplace of the original work. Now, each of those factors is going to be reviewed and evaluated by the court each time, and then they're weighed. There's no magic formula that you need number 1 and number 2 or number 3 and number 4 or all 4 factors. But the courts will weigh each of them and decide whether or not there is a likelihood of fair use. So let's go through those factors one by one. First, we have the purpose and character of the use. The question is whether or not this is a commercial or a non-profit use in general. If you have a use that is a commercial use, that is you are commercially monetizing the use, then that would typically tip the scales in the favor of it not being a fair use. If it is a non-commercial use or an educational use, then that would typically tip the scales in favor of fair use. Just tips the scales. It's not the end of the inquiry yet. All right? We have to look at all 4 factors. The second factor is the nature of the copyrighted work. What kind of work is it? Is it an original, creative, or fictional work? Or is it a factual work or a news story, something that is happening in current events, for example? If it is something that is an original or fictional work, then the scale will tip more likely in the favor of it being a fair use. The third factor is the amount and substantiality of the use. So that's both a qualitative and a quantitative analysis. The amount of the use it's pretty self-explanatory. How much of the work are you using? How much of the work are you using in relation to the original work, and how much of it is in your new work? And the other part of that qualitative analysis says, what is the substantiality of the use? In other words, if I'm only using a small part of the work, I could still possibly be violating the copyright if I'm taking the heart of the work or the hook of the work, right? So amount and substantiality will be the third factor that the courts will look at. The fourth factor is the effect on the commercial marketplace. Is this new work going to negatively affect the commercial marketplace? Is it likely to negatively affect the commercial marketplace? And that evaluation is not based on whether or not there has already been a damage to the marketplace. It's whether or not there is likely to be damage to the marketplace. All right? So that's our fourth factor. Courts have actually placed a little greater emphasis on that fourth factor, the effect on the commercial marketplace. For obvious reasons, that really is the greatest damage that could be done, if the original work now is negatively affected on the commercial marketplace. So there are three cases that I just want to quickly talk about that really got into this fair use determination. One was Sony versus Universal City Studios. That was a case from the early 80s involving the creation of what became the Sony Betamax. And when this was first created, movie studios were very concerned that they were going to lose the value of their copyrights if people started making videotapes of their works. They brought a lawsuit saying that it was copyright infringement. Courts found, after going through the case facts, the case went all the way to the Supreme Court, and ultimately the Supreme Court held that it was fair use. And the main reason why they found it was fair use is because the VCR, or the VTR as it was called, was capable of substantially non-infringing uses. In other words, it could be used and was likely to be used in non-infringing ways. And one of the ways that they said was a non-infringing use was what they called time shifting, right? You're not home for your favorite 8 o'clock show. You set the VCR, come home and watch it at 10, or you watch it the next day or the next week. That's called time shifting. And the court said that is a fair use. So the Sony versus Universal City Studios was the first real big case in the contemporary parlance that dealt with this. Harm to the marketplace was not presumed, and there was no proof of future harm. The next case I want to talk about was Harper and Row versus Nation Enterprises. That case involved former President Gerald Ford. After he left office, he signed a deal to do an autobiography. When the autobiography was about to be released, his publisher, Harper and Row, cut a deal with Time magazine for excerpts of the book to be printed in an upcoming magazine. Time was to pay $25,000, $12,500 up front, and $12,500 upon the publication. Shortly before the work was published, someone leaked the work to another entity called Nation Enterprises. Nation Enterprises, knowing that they didn't have the right to publish, still published the excerpt from the book. Ultimately, as you might imagine, Time magazine said, hey, wait a minute, we had a deal for an exclusive here. This is out on the marketplace. We're not going to publish. We're not going to give you the $12,500. You violated the contract. So obviously there was a copyright infringement case. The Nation Enterprises defended, saying it was fair use. The court said it was not fair use because they used a substantial amount and had a significant effect on the commercial marketplace. It was clear to show the effect when they lost their deal for the second half of that contract and affected the marketplace for the work. The work was also unpublished, which the court took into effect as well. So that was the second case. The third case is one that is very, very famous, Campbell versus Acuff Rose, case involving the Two Live Crew, rap group from Miami. They did a parody of a Roy Orbison song called Oh Pretty Woman, and they made a mockery of the lyrics. They actually asked for a license to do the work. They were turned down or were ignored by Acuff Rose, the publishing company. They went on and put the song out and ultimately were sued. At the lower court level, the court said, you're using this for a commercial purpose. It cannot be fair use. The case went all the way to the Supreme Court. The Supreme Court disagreed with the lower court and said it was a fair use. It was a commercial parody, and a commercial parody could be a fair use. The fact that they were making money off of it did not render it not to be a fair use. And the court said that it was unlikely to affect the commercial marketplace for Roy Orbison's song. The markets were so different, there was very little likelihood that someone was going to hear the Two Live Crew song, and then say, oh, I don't need to buy the Roy Orbison record anymore now that I've got Two Live Crew. It was so transformative in nature that it was fair use. Now, the other thing that came out of that case is dealing with what rights or how far can you go with a parody if you are trying to use fair use as a defense. And the court held that a parody, in that case and other cases, the court has held that for a parody, you can take as much as is necessary of the original work in order to conjure up the image of that work. In other words, we've got to take something that's recognizable in order for you to know what we're making fun of, right? So in Oh Pretty Woman, the hook, that guitar line in the hook, right? That whole guitar line was the hook of the musical hook of the song. And how else can you let the audience know this is the song that you are parodying if you don't use that hook, right? So courts said that, or courts have said that with a parody, you can take as much as is necessary to conjure up the image. You can't take too much, right? You can go beyond the scope of that. Disney versus Air Pirates case was one where Air Pirates took a little bit too much. They were making a parody, including Mickey Mouse, using him as a flying a plane that appeared to be shooting bullets and trafficking dope, and it was they took too much of Mickey for it to be a parody because they went beyond the scope or the limitations that you would have in fair use. So, bottom line is, in a fair use case, all four of those factors will be evaluated by the courts. If you are involved in using someone else's copyrighted work, make sure you get good counsel on that. If you have any suspicions you may be going too far, then you certainly need to talk to counsel on that, and make sure that if you do believe that it is, or if your counsel believes that it is not a fair use, make sure you request a license, and you'll be in best shape if you do that. All right, so that's it for this week, part 5, the course, copyright law, fair use. We'll see you next time.